So the three suggestions that I have for you when it comes to reading your test questions, reading and interpreting those test questions is one, particularly when it comes to scenario or math questions, always read the last line of the test question first, because that last line is what the test question is asking you for specifically. And then go back up to the top and read the rest of the question all the way through. The reason for that is because we tend to get lost in the detritus. We tend not to be able to see the forest for the trees. So you'll get a question or a scenario and you start reading it and immediately your mind becomes a little bit overwhelmed, particularly I know for a lot of people those math questions um, can just feel like, if so and so's on an airplane going 30 miles an hour, how much time does it take for a papaya to reach the ocean? It reads like that. So if you read that last line first, it'll help you sort out the detritus. Second thing is, you will always be given every piece of information that you need to solve for the question, um, or solve for the answer, but you may be given more information than you need. It's okay to throw stuff out. It's okay to go back to the question and say, for example, if a question is asking you about a document that's needed to request something specific that's not in the contract, but you get all these other details in the question, the answer is still simply addendum. It's okay to kind of throw out some of those other details and go right back to the question because a lot of times it just is that simple. And the third thing is these questions tend to hijack our brain. And if you're a ruminator or an overthinker, and a lot of us are, that is the bane of our existence, right? When we're looking at these questions that we'll select an answer and then we'll go back and we'll go, oh, I don't know. Um, take all of the words that indicate like emotional value or motivator questions. Um, all of those words that are going to cue you in, and I'll give you an example in a minute of something that can hijack our brain, a question that would hijack our brain, and throw those out. You know, and one of the questions that is most commonly used to um, illustrate this is question about, excuse me, Hmm. questions about environmental issues like mold or radon or asbestos. So if you get a question about asbestos on the test that says, you know, how do you dispose of asbestos or gives you a scenario about asbestos, our brains kind of hijack on stuff like that because, it signals danger to us. And there's a psychological research done. It's called the Stroop test. It's really interesting. But keep this in mind because this will help you going forward when you're answering questions on your test. And what it does was it compared people's responses in their brain to words that were neutral compared to words that possess danger stimuli, like cancer. Asbestos would be one of those. Anything that would create a heightened state of arousal, right? And so when we're presented with these danger words, our brain goes into a state of hyperarousal. And when that happens, what that does is it blocks our ability to retain and recall information. And so if you can kind of pull back and understand that place, then while you're quizzing and testing, then those danger words will actually not present that kind of stimulus because once your brain is hijacked, it kind of messes you up for your next set of questions, right? So it doesn't just last for that question, it keeps lasting. So keep that in mind. Now, the answer to that asbestos question that we're talking about is simply the legal answer simply is encapsulate it in a sealed bag. That's it. And most of the questions on the test are going to be like that. So if you feel yourself overthinking, the question follows some of these steps. And at the end of each class that I do for you, we'll run over some questions. Um, and we can look over some of those questions that have some of those more confusing wording and tease that out so that you kind of get used to knowing what to look for. And we'll talk when we get to the quiz at the end today. We will talk about one of the strategies that may help you when you're struggling to choose or select an answer. A couple of the things that you can do that will increase your likelihood of selecting the correct answer. Because this is just a hurdle, right? A lot of this stuff on your test is not going to apply necessarily directly in the field of real estate. So hopefully some of this is helpful. And what just happened there? Hang on, I'm getting a blank screen. All right, sorry, I don't know what happened there. So federal laws ADA and the ADA, you'll note that your learning objectives here, um, and these are the main objectives that you will be tested on. And then you've got your vocabulary and key terms. So with the fair housing law, all real estate professionals have to understand and follow these laws pertaining to discrimination. And these are also known as, equal opportunity laws, fair housing laws, and they expressly prohibit unfair practices in the rental and sale of real property. And they affect every step of the process from advertising and listing to closing and managing of property. RESPA and TILA came out of these federal laws, and we are all bound by them. And whether or not, you know, I think most licensees go in not tending, we would never tend to discriminate against an individual or a group of people, but it's important to understand also the subtle ways that can inadvertently happen through no malicious intent, because whether it's malicious or not, in the eyes of the law, it's still discrimination. And I think the the topic that we can we can point to most where this occurs is in places like steering. Most of the time, um, steering is kind of unintentional. We don't set out to push our own agenda on our clients, but it happens often, and just because we are all raised with a certain set of stereotypes. And one of the things real estate um, can really teach you to do if you do it right is to listen deeply so that your client is the one that is in charge and empowered, and they're the one that's directing you. You're an advocate, you're a fiduciary, you're an information provider, but they are in charge. And that can be a difficult line to walk, but if you learn to listen and do it well, can be ultimately just so rewarding and create best case scenarios for everybody involved. So one of the very first sweeping acts of legislation to work toward eliminating discrimination was the 13th Amendment to the Constitution. And this identified all United States born or naturalized persons, including freed slaves at the time, as citizens. Now, at the time, women were counted as citizens, but could not yet vote and hold property. And in fact, generally, in the broader sense of the word, it wasn't until 1974, with the Equal Credit Opportunity Act, that women were brought into a more fuller opportunity for ownership under the law. So to reinforce the 13th Amendment, the Civil Rights Act of 1866, this was actually on my test, was passed by Congress. And it specifically stated that all citizens of any race or color, except for Indians at the time, and I'm quoting that directly, of course, of the United States shall have the same right in every state and territory as enjoyed by white persons thereof to inherit, purchase, lease, or sell, um, or convey real and personal property. Well, this was hugely important because before that time, only basically upper class white landowners were afforded that opportunity. And the law is still in effect, and it's important. But at the time, it only included race and color. So, about 100 years later, the Civil Rights Act of 1968 was passed by Congress and prohibited racial discrimination in the sale, leasing, and financing of property. And that was known as the Fair Housing Act. That is also on your test. And so its purpose was to provide fair and equal housing opportunities. And this act of legislation was way more stringent and inclusive and applied in all of those cases where it hadn't been applied previously. The landmark case that you want to know about for this particular section of federal laws is Jones versus Mayer. And it was a Supreme Court ruling that held that a private individual could not discriminate in selling or renting real property because of race. And the issue at hand was whether the statute in 1866 actually applied to private parties. And then the court ruled at that point that the Congress had the power to enact as necessary and proper for abolishing all of those incidences of slavery and discrimination in land ownership in the US. So it made a really sharp distinction between the Civil Rights Act and the Fair Housing Act, which applied to just more than racial discrimination. And that's where it also applied steering, blockbusting, and redlining. And so while the Civil Rights Act of 1968 kind of broadened which classes were protected, it also contains several exemptions. And for the purposes of your test, these exemptions are important. So exemptions are given to certain residential properties relating to the sale or rental of a single family home. Now we know a single family home is 1 to 4 units. That's what qualifies as residential property. And to qualify for an exemption, all of the following conditions have to be met. The home has to be owned privately. The owner doesn't have more than 3 single-family dwellings. And if the owner doesn't occupy the dwelling, the exemption only applies to one sale within a 24-month period. So only one every 2 years. And the exemption only qualifies if the homeowner doesn't use a real estate professional, doesn't advertise using discriminatory wording, so can't steer toward or away from groups or individuals specifically, or the rental of units, provided that the owner occupies and maintains one of those units as a resident. So those are your exemptions as far as what qualifies as residential and fair housing. You may have 1 or 2 over these, but where you're going to get a majority of your questions is over the Fair Housing Amendment Act. So in 1974, and so many laws regarding TILA, RESPA, fair housing, equal credit opportunity were enacted during the 70s. It really was a revolutionary decade when it came to looking at discrimination and who those protected classes are, the laws were amended in 1974 by the Housing and Community Development Act, which then prohibited the discrimination of sex. So now we have race, color, and sex that are protected under the law. And this prohibition was necessary as women found that they were being discriminated against by being denied housing and loans. And part of what these sweeping acts of legislation did were to make it illegal to discriminate based on whether the source of income for women was based on alimony or child support or the source of funds, things like that. Up until that point, women couldn't even, generally speaking, unless they were extremely wealthy, um, get a credit card in their own name. So I was born early to mid 70s. So, um, it's kind of hard to imagine that in my childhood, that my own mother still couldn't have her own credit card, without a man's signature on it. And then these laws were amended again. So we have race, color, sex, by the Fair Housing Amendment of 1988 to include familial status. And what this means is that persons living or expected to live with children under the age of 18 and mental or physical handicap or disability. And then further, religious preference was included and prohibited any real estate professional to mention a specific religion in their advertising practices. National origin was included to protect immigrants who found themselves the target of unfair discrimination due to their ethnicity. And so then other persons under the law that would be protected would be people with hearing or visual impairments, people with HIV or AIDS at that time, cognitive or intellectual impairments, those with a mental health diagnosis, those recovering from drugs or alcohol, provided they've been in treatment or were in treatment and not relapsed, of course, and those who were non-disabled but associated or lived with someone with a disability. Now we know realistically that subtle discrimination happens all the time. I mean, when people get rejected for housing and other things, that there's always another reason cited. But the law specifically broadened its inclusion to those specific groups. Now, regarding protected classes, it is illegal to do the following: refuse to negotiate rent, sell, or lease to a person who's made a bona fide offer. Deny or make housing unavailable, fail to consider an offer, fail to accept an offer, use any sort of different application criteria, and we can talk. We're going to talk about redlining a little bit in a minute because that was extremely common practice. Impose different sale or rental charges, eviction. They can't evict tenants. And they can't advertise or make statements that indicate like a limitation or preferences which are discriminatory. And this includes verbal statements. And then finally, they cannot disallow any individual from inspecting a property that is available for sale or rent. And what these laws do is provide additional protections for consumers by disallowing the commercial lenders to deny or make different criteria for certain populations and individuals. And again, that's not to say that in real life that didn't or doesn't happen and isn't subversive, but these laws made it much more difficult, and more importantly, in the enforcement, made the penalties much more severe for when that occurs. So the fair housing law is not just designed to protect the consumers who are tenants or lessees, it provides a framework to make it illegal to commit unfair practices. Any questions up until this point? Steering. Steering is the practice of directing home seekers away from certain locations and toward other, usually less desirable neighborhoods based on any of those following: race, color, sex, religion, national origin, um, disability, or adult only housing. Um, of course, it includes efforts to, exclude minorities from certain areas, showing certain neighborhoods only to certain individuals. And it can be subtle. I think we all get steering in broad terms. But when I came into real estate, one of the one of the things that I bumped up against was my own inclination to, want to put someone in their safest, in the safest location that they could be. And I don't practice transactional real estate. I actually don't. I love reading contracts and I love doing contract law, but I don't find a lot of joy in the transactional process. But one thing that I agreed to do for my brokerage was, if there was an individual or a family that was from an underrepresented population or a minority population, that I would be willing to represent them in their search for a property or a home. And it is because I have seen, I've lived in a lot of different places, and I have seen what discrimination and housing, the lack of affordable housing can do to people, and how subtle that can be. And I think because most of us go in with best intentions, our impetus is to want to put someone in the safest place. And so one thing I bumped up against was, say, if I was representing someone from, say, an LGBTQA population, or someone that um, was English was their second language and from a different country, it was my inclination to want to use what I knew to put them where I thought would be safest for them. And I'm making a whole lot of assumptions by doing that, right? Um, because just because I think is something is safe and the best location doesn't mean that it is. And what I'm still doing, even through my best intentions, is taking the power away from my clients. So my only job is to listen, to provide all the information that I can, including websites and other appropriate sources of information where a client can get things like demographics, crime rates, information about transportation and school systems on their own, and then have them tell me where they want me to take them. So conflicts in understanding steering, I think, are natural, especially when you have a client's best interest at heart. But we all have we all have stereotypes and these frameworks that we operate under, and they're almost always in error. Humans are terrible judges, and it's not our fault. We're all raised a certain way. But by listening and empowering your client, you can avoid steering even when your intentions are good. Blockbusting, sometimes known as panic peddling, and what this means is it inducing panic in a neighborhood for personal financial gain. A a lot of this really started happening in the 40s, 50s, and 60s when there was a migration away from cities into the suburbs where wealthy white folks lived. And, um, when broader groups of population started moving outward into the suburbs, land developers or landowners, or people who wanted to buy homes would go into these neighborhoods and basically say, because women, Black, brown people are moving into the neighborhood, it's going to drop your property values. And by doing that, they call that panic peddling, um, and indicating that your property values are going to decrease, social services are going to decline, crime rates are going to go up. It reinforced these fears and negative stereotypes in residents that the neighborhood is changing. And so that would snowball. And then a significant number of homeowners in the area would sell those properties for cheaper. And then those homes would be sold to incoming residents at higher rates. So blockbusting applies to individuals, firms, brokerages who attempt to gain listings by playing up fears about things like upcoming projects, like expressways or airports. That's how that manifests itself. And then lastly, redlining is a practice whereby a lender refuses to make a loan or places certain restrictions without considering an applicant's qualifications. It literally means that a lender has drawn a red line around certain geographical areas with the intent of placing restrictions or denying loans to people who live in that area. And how this pans out is it means a lender can't refuse a loan because of crime rates or ethnicity, um, legal source of funds, marriage or familial status, or any other sort of discriminatory criteria. All right, any questions about steering, blockbusting, or redlining? And the reason I kind of elaborate on these particular concepts is because when you get a question about one of these on your test, it's likely to be in scenario form. And so hopefully, um, and never hesitate to jump in with a question or a discussion point, because it's discussion and questions that are going to increase your ability to retain and recall this information. All right, the Americans with Disability Act, kind of the final um, topic area in these initial federal laws. So, purposes of the Americans with Disability Act was to eliminate discrimination, of course, against those with disability, and allow these individuals to enter the mainstream, social and economic mainstream. And we still struggle with this. There's no perfect world with providing equal opportunity in employment and transportation and communication and access to goods and services. And for any of us who are disabled or have taken care of or have direct relationship with someone with a disability, we get how imperfect the world is when it comes to accommodating people with disabilities. Um, if you have spent even a week with someone with even a moderate impairment navigating the world, you get how unbelievably cumbersome that becomes. But the Americans with Disabilities Act does its best to try and eliminate as many of those um, obstacles as possible. So, with the passage of those fair housing amendments in '88, when Congress prohibited discrimination against those with physical and mental disabilities concerning housing, the law didn't apply to any other type of real property besides housing. So when the Americans with Disabilities Act was passed by Congress in 1990, a portion of that law address the issues surrounding discrimination in public accommodations and broaden that to things like commercial facilities. So commercial facilities are defined as private and intended for non-residential use. And those include places of employment, like corporate offices and things like that. So Title I of the ADA covers employment discrimination for employers with 15 or more employees. And this means that it could require them to restructure environments or scheduling, um, modifying policies, things like that. The Title II portion covered the government employment and programs, activities, and services. And then the Title III portion of it called for full and equal enjoyment of goods, services, facilities, and privileges of private entities that are serving the public. And what that meant is that these entities had to remove architectural and communication barriers, and to modify policies and procedures, and include aids and services that to overcome those barriers to prevent someone who's disabled from getting the same access or enjoyment from their work or whatever activity that may be as someone who's non-disabled. The exemption can be made is if those changes would alter or damage the nature of the goods or services or pose a direct threat to health and safety, but otherwise, those remain pretty firm. And so the ADA was enacted to guarantee those with physical or mental disabilities equal access to transportation, public transportation, public accommodations, employment, state and local government services, and telecommunications. This is when we started seeing a lot of those accommodations for hearing impaired individuals. Specifically for your test, you are going to want to understand the difference between accessibility and adaptability. So the policies that require accommodations so that a tenant can have full enjoyment of a premises include the accessibility and adaptability laws. And those are the two terms that define the parameters for fair housing. These only relate to multifamily dwellings, so more than 4 units, and only when construction was completed after March of 1991. So multifamily housing after March of 1991. Readily accessible means that a disabled patron will be able to access and enter and use that facility even if the whole structure can't be made completely accessible, it must be structured in a way that would comply to the extent possible. So accessibility would mean that the ground floor units of a building must all be accessible. But if the building has an elevator, then all the units have to be accessible. And accessible means someone in a wheelchair can get to and into the front door. That's the specific criteria. Adaptability is different. The test for adaptability means that units that are required to be accessible must also be able to be adapted for the handicapped. On your test specifically, what that means is environmental controls and electrical outlets and sources must be reachable from a wheelchair and that the wheelchair can get through all the doorways. Bathroom walls have to be reinforced in such a way that grab bars can be installed if necessary. And kitchens and bathrooms must contain enough space to allow a wheelchair to maneuver in a way that doesn't limit the tenant's ability to utilize the necessary space. So when you see questions involving adaptability, go straight for those environmental controls, items at wheelchair height, and the ability to maneuver. Those are going to be your criteria. And all brokerage firms have to comply with all of these federal, state, and fair housing. The penalties for violating the housing laws are pretty severe, and they can be enforced in one of three ways. And of course, problematic is the burden of proving discrimination falls on the person filing the complaint, but can result in sanctions and penalties. So fines, which can incur are up to $75,000 for a first offense, and no more than 150,000 for subsequent offenses. And of course, civil fines and injunctions can be imposed. So you can imagine that, if someone goes into a multifamily housing unit and there are 15 or 20 of these offenses committed, that, these fines can rack up into the millions of dollars very, very quickly. And there are also criminal penalties for those who coerce or threaten or intimidate or harass or interfere with any person that they buy, sell, rent, or lease to. So the lending laws, res fall under this umbrella. The credit, um, Equal Credit Opportunity Act, um, focusing on that discrimination practiced by lenders, also extends to property managers. Just so you know, those truth in lending, um, everything concerning like right of rescission and truth in lending laws all fall under that federal fair housing. And for the Utah students here, um, note that specifically for Utah fair housing laws, they prohibit discrimination in lending based on the source of funds, like public assistance or public aid. So um, the Respatila integrated disclosure was implemented in 2015 and consolidated, just a place of note, all of those existing federal disclosures and protections. Um, things like the APR, advertising and the use of trigger terms, um, and required additional disclosures, amount of percentage of the down payment, terms of repayment, etc. So your RESPA and TILA items are generally covered under a different umbrella, but do note that those federal laws also include things like those lead-based paint disclosures, um, any of those environmental issues, mold, asbestos that we talked about earlier. So when you're looking at your summary of key points, which you have right here, and I encourage you, if you're a paper person, um, print out these learning objectives, summary of key points and quizzes, and just kind of, keep them as a binder, so that you can move along. All of these summary of key points encapsulate what you will be tested over as far as um, your national exam. And another testing point I'd like to make, which will really help you in the process, and again, keeping your brain from being hijacked. I've spent years studying um, the brain and memory and retention. 25 years, as a matter of fact, studying memory and retention. And when you are quizzing, because of course, you're not going to be able to use your books or notes during the test, but it is okay to kind of move through a test and see what you know without referring to anything else. But if in your curriculum process and your quizzing process, if you get stuck on a question and you start overthinking it, it's going to hijack your brain, okay? And it's going to create an environment anxiety around the test questions. And I am sure that there are some of you here at least that already suffer from test anxiety, right? You don't need any assistance in being anxious about testing. A lot of people out there just say that they're poor, yeah, doubting yourself, that you're poor test takers. And this is something that you can do to really help keep that keep that down is when you bump up against a question where your brain just starts to spin, go back to what the question is asking you. And if you have to, don't give yourself too long to agonize over it. Look it up, get the right answer, and answer it correctly, because that will reinforce the right answer in your brain and cut off that state of hyperarousal. Because once you get to a certain place, your parasympathetic nervous system is freaking out. And you can't very easily at that point bring yourself down. So if you're already prone to that, use your notes to test. It is okay to do that. It will actually reinforce a correct answer rather than having you struggle over a wrong answer. Because if you do keep struggling over that wrong answer and agonize it over it, the chances that you'll miss it again or doubt yourself when you run across a question regarding that particular topic area actually increase. So it's not cheating. It's not, it's not like you can use these during the test. It's not an easy way out. It's just reinforcing your ability to retain and recall the information for this hurdle that you have to jump over in order to get your license. Does that make sense? All right. Let's take a look at the quiz. We'll go through it together and we'll grade it and we'll call it good. And I thank you for bearing with me while I'm still so not well. Okay, question number one. Do you want me to share screen this document? See if I can without it killing my resources here. I'll see. No, just look at yours and I'll read it out loud. So under the 1866, excuse me, laws regarding unfair discrimination, which of the following is true? A, you cannot discriminate because of a person's nationality. B, all women had the same rights as men had. C, American Indians' right to own property were protected. Or D, all people were to be treated equally without regard to color or race. Two, under the 1968 Fair Housing Laws, which of the following is not one of the protected classes? I'm just going to give you a little bit of for those of you who have trouble, and a lot of us do, our brains have kind of a hard time with all of the following except questions. You can do one of two things. You can reframe the question and say, under the 1968 Fair Housing Laws, which of the following is true about protected classes, or which is the following is not true. Either way, when it comes to your answers, you can just answer true or false to each item, and the odd one out is going to be your correct answer. So if you get stuck with those all of the following except, you can pull out the except and make it which of the following is true. Just do true, false, 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 or true, false, 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 true. But the odd one out is going to be your answer. So A, race, B, sex, C, religion, or D, color. Number three, which of the following persons might be most likely to be found guilty of redlining? A real estate broker, a title officer, a lending officer, or a sales agent? Number four, which of the following fits one of the added classes from the 1988 Fair Housing Amendments Act? A Black person, B, a paraplegic, C, person 50 years old, or D, a person who is Catholic. Number 5, the Americans with Disabilities Act covers all of the following situations except A, a mobility impaired person seeking employment, B, a blind person who would need to have their seeing eye dog at work, C, a person who is addicted to illegal drugs, or D, a wheelchair-bound person wishing to attend the theater. Number 6, under the Truth in Lending law, the right of rescission would apply in which of the following situations? A, the buyer has decided it's too much money to spend on the purchase of a car. B, the borrower decided the interest is too high and wants to cancel the loan. C, the consumer decided to wait a few months to make the purchase. Or D, the buyer changed their mind for no reason at all. 7, the Real Estate Settlement Procedures Act covers which of the following? A loan to a corporation to buy a small apartment building. B, a loan for a purchase of an apartment building. C, the loans for a purchase of a single to 4-family dwelling. Or D, a loan for construction of a medical building. I'll give you a little hint on this one here since we didn't really go into RESPA TILA. RESPA applies only to residential loans. And so by process of elimination, you could probably yourself already go corporations, apartment complexes, and medical buildings, which are commercial. Rule those out. That one's different. But just so you know, RESPA only applies to residential. Number 8, a real estate agent communicates to a couple looking to purchase a home that they would not be comfortable with the existing residence. This is an example of A, blockbusting, B, misrepresentation, C, steering, or D, assignment. 9, a particular bank has blocked out certain neighborhoods in a community where it will not pay loans due to crime rates. This practice is called A, relocation, B, warehousing, C, steering, or D, redlining. And 10, we did not cover, but I'm going to give it a quick nod. Okay, so the Sherman Antitrust Act was passed specifically to combat A, kickbacks, B, blockbusting, C, price fixing, or D, steering. Okay, I'm going to give you a quick note about the Sherman Antitrust Act, so that you've got that. You probably will be asked at least a question about this. So the purpose of the Sherman Antitrust Act is to promote competition in the open marketplace. What this means in the real estate industry is, which recently came under fire, as we know, from asserting that it basically works to prevent price fixing with commission rates. So what this means is that a brokerage can establish whatever compensation fee or structure that it wishes. So it can be like a percentage or a flat fee or a combination of the two. And the amount of the compensation is negotiable between the broker and the client. But the Sherman Antitrust Act is self-regulatory in that what it does is it regulates the industry in a way that most brokerages have to be competitive with each other, right? So, if brokerages are charging like 3% to 2.5 or 3% normally, and that's the norm, then the brokerage can't get away with establishing like a 6 or a 7 or 10%, right? This is also why things like regulates things like net listings and stuff. So, a broker can't go and say to a client, if I promise to sell your house for $450,000 and you net $450,000, I get to keep anything above and beyond that, right? Because if the house sells for $700,000, I mean, you know, $250,000 commission, no. So the Sherman Antitrust Act um, essentially combats price fixing, uh, and that was its main goal. So um, this is also one of the kind of discretionary ethical policies that come out of this is not not discussing fees with anyone outside your office except the owner of the property. You can't you can't, it's part of your fiduciary duty, really discuss that. So that's the Sherman Antitrust Act. If you see something on the test about that, it was passed to combat kickbacks. So, some people just weren't making more than others with dirty money. All right, as far as the answers were concerned, we have question number one was D. Sorry, I got my papers all messed up there. So D, all people are to be treated equally without regard to color or race. Number two was B, sex. Number three, C, lending officer. Four is B, a paraplegic. Five is C, a person who is addicted to illegal drugs. Remember the caveat to that is if they have they are in rehab and continue to stay clean, then they cannot be discriminated against. Number six is B, the borrower decided the interest is too high and wants to cancel the loan. Seven is C, that purchase for the single 1 to 4 family dwelling. Number eight is C, steering. Number nine is D, redlining. And number 10 is price fixing. Any questions? So remember that price fixing is concerning fee structures. If you see anything about the Sherman Antitrust Act and fee structures, it's to prevent um, price fixing and shutting out smaller brokerages or other brokerages. Any questions? I
Yes,
am going to go ahead.
quick. Okay, so when you say price fixing, it's fixing the purchase price so that a second person can get a kickback. Is that what you mean by that?
Well, what it does um, essentially is when we're looking at price fixing, and I'll give you a scenario. That'll probably be the best way to explain it. So what used to happen a lot in the real estate industry, and when it was really, really a good old boys club, is that there would be groups that would get together, brokerages or individuals that would get together and price fix fees, um, and generally higher fees, higher commissions, and things like that. And then they would group boycott other brokerages and like trash other brokerages. And so, um, what this would do is force people to use certain brokerages at those higher price fixed fees because of the group boycotts of other brokerages. I know this is all it's all very sociological. Um, But what it did was it drove out of business individuals and smaller group brokerages and didn't allow for fair commissions and fair prices. And so consumers were paying the price for that. And when the Sherman Antitrust Act came along, what it did was specifically, the law specifically stated that those fee structures could be established, but had to be negotiable with the client. So that certain brokerages couldn't just boycott other brokerages or drive individuals out of the field, drive up their own fees and commissions and prices. So consumers only had, one group of people to go through in order to sell real property. And then, of course, these people are banking on it. What it basically did was restrict free trade, right? And so, with the law laid down saying, brokerages can't be non-negotiable with prices. The law says, you can set a fee structure, but they have to be negotiable under certain circumstances. You can't price fix and you can't group boycott. And by laying down those laws, it allowed the industry to regulate itself. Because if you can't group boycott and you can't price fix, if you have 10 brokerages and most of them are at a 2.5 or 3% commission structure, right? And then one's at a 7% commission structure, no one's going to go to that 7% commission structure, right? So it created a self-regulatory body. I think for the purposes of the test, awesome. It's kind of it's really technical. It's really intricate, but I think for the purposes of the test, if you can understand the um, by making illegal group boycotting and price fixing, it just stabilized the industry. Then you've got the test answer for that. So any other questions? For those of you who don't have it, I'm going to put my email in, oops, the chat window. Do not hesitate to get in touch with me. Like I said, for every section, um, I have learning objectives and quizzes. I'm more than happy to answer questions about how you're moving in your curriculum, anything about the testing process. I'm more than happy to provide resources. I rewrote the broker book a couple of years ago. So I have vast amounts of material that will assist you. And yes, Stacy, I can. I'd be more than happy to assist you in how to most effectively study for your test with the materials that you need, so that you can be successful in your testing process. And it may be, I've been in the hospital, I've been very, very ill. But I should be back in the game in a day or two. So if you send me an email, um, I will I will be more than happy to shoot you the items, and every session that I do um, on the Talkify calendar will also include all these items in our sessions, okay? All right. I hope you guys have a fabulous week and be well, and I'll see you next time.